Let's spend a few moments digesting what has happened. It actually is a pretty significant decision. It is titled New York State Rifle and Pistol Association versus Bruen, Superintendent of New York State Police. This case before the Supreme Court is pretty simple to explain. In Bruen, two individuals, Brandon Koch and Robert Nash, they're New York residents. They applied for concealed carry permits to carry their guns in public for self-defense. New York and 6 other states have may issue licenses. That is, in most states, so 26 states have constitutional carry. Constitutional carry is once you've lawfully been able to purchase your gun, you have the background check, you fill out the paperwork, you get the gun, you can carry that gun, open or concealed in most cases. Some states are you can openly carry, not concealed carry without a permit. Most states are you can just carry your gun in public, concealed or open, without additional paperwork. So that's 26 states. Now I gotta do the math in my head here because I went to law school so I could avoid the math. So the other 17 states, so 26 states have constitutional carry. 17 states have, you got to fill out a form and get your fingerprints. Some states also make you go through a gun safety class and learn gun laws. And then once you've gone through learned the gun laws, taken the gun safety class, gotten your fingerprints done, and in some cases a mental health check, then you can get your concealed carry permit. What 7 states do, including New York, California, Illinois, and a few others, they're all progressive states. What they do is have a may issue permit. And what that means is you have to go to court and say, please, sir, can I have a concealed carry permit? And the judge may give it to you, but doesn't have to give it to you. It's called subjective discretion. And conservatives don't like subjective discretion. You shouldn't be allowed to treat 2 law-abiding citizens differently just because you believe one guy's excuse and you don't like the other guy's excuse. And that is the situation with New York. New York has a may issue rule. In a 6-3 decision before the Supreme Court today, the U.S. Supreme Court's conservatives, Sotomayor, Breyer, and Kagan in dissent, said that concealed carry permit requirements are constitutional so long as they are must issue. So long as any citizen can do the exact same requirements, they can get a concealed carry permit, as long as there's no subjectivity for the issuing officer to give them the concealed carry permit, they can get it. It is a striking decision. Now, if you want to learn about gun laws and gun history, I can't, other than the Heller decision that Justice Scalia wrote, this decision issued by Clarence Thomas. Today, by the way, is Clarence Thomas's birthday, and he's issued the decision. He really breaks this down. Let me read you part of this. New York is not alone in requiring a permit to carry a handgun in public. The vast majority of states, 43, are shall issue jurisdictions where authorities must issue concealed carry licenses whenever applicants satisfy certain threshold requirements without granting licensing officials discretion to deny licenses based on a perceived lack of need or suitability. Meanwhile, only 6 states and the District of Columbia have may issue license laws under which authorities have discretion to deny concealed carry licenses even when the applicant satisfies the statutory criteria, usually because the applicant has not demonstrated cause or suitability for the license. Aside from New York, then, only California, the District of Columbia, Hawaii, Maryland, Massachusetts, and New Jersey, I said Illinois, it's not on the list, have analogs to the proper cause standard. All of these proper cause analogs have been upheld by courts of appeals, except for the District of Columbia's. Petitioners Brandon Koch and Robert Nash are law-abiding adult citizens of Rensselaer County, New York. Koch lives in Troy. Nash lives in Averill Park. The New York State Rifle and Pistol Association is a public interest group that defends the Second Amendment. Both are members. In 2014, Nash applied for an unrestricted license to carry a handgun in public. He did not claim any unique danger to his public safety. He simply wanted to carry a handgun for self-defense. In 2015, the state denied Nash's application for an unrestricted license, but granted him a restricted license for hunting and target shooting. In 2016, Nash asked a licensing officer to remove the restrictions, citing a string of recent robberies in his neighborhood. After a hearing, the officer denied the request. The officer reiterated Nash's existing license permit to carry concealed for purposes of off-road, backcountry, outdoor activities similar to hunting, such as fishing, hiking, and camping, but emphasized the restrictions were intended to prohibit Nash from carrying concealed in any location typically open to or frequented by the public. Between 2008 and 16, Koch had the same position. He faced no special danger, but wanted his gun for self-defense and was denied. That's the background here. Well, Clarence Thomas made very clear that you can't do this. In fact, Clarence Thomas did something else. A majority of the states, a majority of courts of appeals, and the federal government under the Biden administration asked the court to do something specific. Knowing where this was headed, the court proposed a two-part test and said, we need you to do this two-part test. First of all, is this a Second Amendment issue? And secondly, if it is it in some way a reasonable restriction based on current circumstances? And now I'm summarizing that badly, but you got to understand, essentially, the courts begged for a two-part test, asking, please, Supreme Court, if you're going to go this way, and we think you are, please use our recommended two-part test. And the court said, absolutely not. We're not going to use a two-part test. What we're going to tell you is that if it's a constitutional right, it's a constitutional right. What you got to do is you got to look at, is it a right to keep and bear arms? Yes. Historically, does this type of request fit the fact pattern of American history? That's what we're doing here. We're not doing your convoluted two-part test. We're not complicating a constitutional right with all sorts of two-part tests that essentially will continue to give courts discretion. Now, why? Why is that? Because it's a constitutional right. Because you exercising a constitutional right should not have to get permission from the government to be able to exercise your constitutional right. I'm going slow as I talk. You may appreciate that because I'm trying to get to the particular passage here that I wanted to find. Yeah, here we go. This is it. This is the test. Heller, which was the case that said the Second Amendment is an individual right, rejected the application of a judge-empowered interest balancing inquiry that asks whether the statute burdens a protected interest in a way as to extend that out of proportion to the statute's effect. And so this is what they wanted. They wanted a two-part test. Let me read you what Clarence Thomas says. Clarence Thomas specifically rejects a two-part test. The test we set forth in Heller and apply today requires courts to assess whether modern firearm regulations are consistent with the Second Amendment's text and historic understanding. That's it. No two-part test. Now, he points out, before you say, well, wait, historic understanding was muskets. He points out that as the Heller discussion and the right to keep and bear arms said, you've got to evolve to some degree the application. So, for example, putting a tracker on someone's car, that didn't exist when the Sixth Amendment was formed. The no unreasonable search and seizure constitutional amendment was formed. But you can say it's an unreasonable search and seizure to track someone to see their whereabouts, to figure out where they're going and the like, that's an invasion of privacy, even though those trackers didn't exist with the Sixth Amendment. So don't say, well, obviously, then we're stuck with muskets here, and that's what it means. No, no, no. It means weapons of war, and that's very interesting here, because what the Supreme Court is saying is this applies to weapons of war. More specifically, though, this case is about handguns, not rifles. And Justice Kavanaugh, in a concurrence, says that we're not throwing out. The Supreme Court is not, contrary to all the hype, contrary to all the fear and scenarios you may be hearing from people, the Supreme Court is not throwing out concealed carry requirements and laws. What the Supreme Court is doing, though, is saying there is history in this country for you, once you buy a gun, to have to get permission to carry it in public. But the history is do X, Y, and Z and you can carry. The history is not do X, Y, and Z, then maybe we'll grant you permission. So what the court is saying is that historically in this country, you have the right to possess a gun. And historically in this country, you have the right to carry your gun in public, where the public congregates, outside of certain sensitive areas like courthouses, legislative assemblies, hospitals, and schools. And if that's the case, you cannot allow some busybody bureaucrat to deny you the right to keep your gun on you in public. You can't give a bureaucrat discretion here. You either must be allowed to carry it or not carry it. You can't tell the bureaucrats, y'all got to decide this based on your whims. That's what the court has done. It's a huge victory for the Second Amendment. And I got to tell you, Thomas pointed out, if you don't think there was a right to carry firearms in public, read the Dred Scott decision. Yeah, Thomas actually went there. He points out that Chief Justice Taney lamented, if black people become citizens, they'll be allowed to carry guns in public, and we can't let that happen. Clarence Thomas uses Taney's words against him to say even the Chief Justice before the Civil War thought we had a right to carry guns in public. He just didn't want black people to have that right, and that's why black people should have that right. Yes, Clarence Thomas went there and established that right today on his birthday.